Hello everyone, and welcome to the first of our video tutorials on lay people. In this video tutorial we'll be looking at lay magistrates. In the legal system of England and Wales there's a history of involving lay people, namely people from the local community who are not required to hold any legal qualifications, in the judicial decision-making process of the courts. And these are justices of the peace or magistrates. And these magistrates have been termed lay magistrates to differentiate them from district judges who also work in the magistrates court. And I've got a picture here of inside a magistrates court, and the three people here are our lay magistrates who are being assisted here by a justice's clerk, and we've got an usher over here. And we're going to see that magistrates are not paid, they are volunteers, and they are able to claim an allowance for loss of earnings, mileage and subsistence, but they are volunteers working in the legal system. And as you can see here, magistrates generally sit in threes in order to give a judgment in magistrates courts, youth courts and family proceeding courts. And the lead magistrate here, known as the chairman, is sat in the middle, and we're going to see that they deal with less serious criminal cases such as minor theft, criminal damage, assaults, public disorder and a lot of motoring offences. And there's a little video clip that's really useful, I think. I've embedded it into my PowerPoint, but really useful to have a little look at that because it shows you inside the court and the magistrates talk a little bit about their role. A bit of history for you. Lay magistrates have their origins in the 12th century when Richard I appointed keepers of the peace in 1195, and the title Justice of the Peace derives from 1361, and an Act of 1327 referred to good and lawful men to be appointed in every county in the land to guard the peace. And we still have Justices of the Peace, and the power confirmed to them by the Justice of the Peace Act 1361 is to bind over unruly persons to be of good behaviour. We know that they're lay people who are volunteering to hear cases in the magistrates court, and they have a huge workload dealing with approximately 95 to 98% of all criminal cases, and they actually make up 85% of the judicial community. So most of our judges are these unqualified lay magistrates. In 2016, we had 17,552 lay magistrates, which you can see is a big reduction to what we had in 2012. And as I've already said, you've usually got a panel of three supported by a legally qualified justice's clerk there. Now on the exam 1, you could get given a 10 marker asking you to explain the role of lay magistrates. And magistrates have a huge and varied workload, and I've bullet pointed the key points for you on this slide. There's approximately 1 million cases heard in the magistrates courts each year, compared to, we know there's 50 or 60 on average in the Supreme Court. So 1 million cases, a huge volume of cases. And magistrates deal with approximately 95 to 98% of all criminal cases, because thankfully most of our criminal cases are less serious and can be dealt with in the magistrates courts. We know from our study of criminal process that magistrates also hold early administrative hearings where they decide on whether people should get bail, whether legal help, legal aid can be provided. They try all summary offences such as common assault, and they try most of our tribal either way offences such as section 47 ABH, and even the indictable offences which they're not able to hear because they don't have the power, they send those for trial, so they commit those to the Crown Court. And magistrates have a dual role. They act as a judge and a jury. So they are deciding firstly whether the defendant is guilty or not guilty, and they also decide on the sentence if they find them guilty. And they've got fairly limited sentencing powers in terms of imprisonment, so they can sentence up to 6 months or 12 months for consecutive sentences. In the past, they could only fine up to £5,000, but since 2015, they've actually got unlimited power to fine. They can send a defendant to the Crown Court just for the sentencing if they think they need a more stringent prison sentence. They try most of our offences committed by young offenders who are aged 10 to 17 in the youth court. And as I've already mentioned, they deal with bail, they deal with legal aid, they also issue search and arrest warrants to the police, and they also have some civil jurisdiction meaning power, dealing with things such as non-payment of council tax and TV licences. And they can also sit with a circuit judge in appeals to the Crown Court. So you can see they have a huge role. And if you were getting a 10 marker on this, we want lots of detail on these roles that they have. Just to come back to the fact that mostly what they're dealing with is criminal offences, but as I mentioned, they do have some civil jurisdiction dealing with non-payment of council tax, TV licences. They can also issue licences to betting shops and casinos and hear appeals from the local authority on licences. So it could be that your question asks you about their criminal and civil role, so that's just the distinction for you there. So magistrates are unqualified in law. They don't need any legal qualifications at all, which is quite surprising, but they are assisted by a justice's clerk. And the justice's clerk will be legally qualified lawyers with a minimum of 5 years experience. And their role in the case, they sit in front of the magistrate. So here's a magistrate here. This is the justice's clerk in front of them. And they're going to advise and guide the magistrates on questions of law. But they are not to influence the magistrate's decision. So it'll be the magistrates making the decisions, but they get advice on points of law from the clerk. In order to be a lay magistrate, the person must be 18 to 65, although we'll see that most of our magistrates are much older, fall into the older category. They must commit to at least 26 half days per year. Remember, they're not getting paid, they are volunteers, but this is the minimum they are required to commit to. And they mustn't have any serious criminal convictions, not been banned from driving in the past 5 to 10 years, and also not have been declared bankrupt. And in 1998, the Lord Chancellor set out 6 key qualities which candidates should have. They're all a bit woolly, to be honest with you. They sound quite similar. They've got to have good character, good understanding and communication skills, social awareness, etc. So these are the qualifications that you need. So we'll have a look at the selection and appointment process. So we have about 700 new magistrates appointed each year, and since 2013 they're made by the Lord Chief Justice, and he relies on recommendations that are made to him by the LAC, the LAC, which stands for the Local Advisory Committee. Now, if you want to become a magistrate, it's a very similar process to applying for any job, really. Positions will be advertised in local newspapers, for instance, and the next stage is that the person wanting to be a magistrate will check their eligibility. So they'll go back to those qualifications and check that they have these qualities, they fall into this category, and none of those things apply to them. And once they've checked their eligibility, they fill in an application form, and references will be required. And after that process, the LAC, or the Local Advisory Committee, will invite candidates to interviews. And there are 2 interviews. The first will be where they look at the magistrate's general character, their communication skills, and if they pass through that interview process well, they'll be invited to a second interview where their judicial skills will be tested. So in that second interview, they might give them example cases where they ask magistrates to make decisions based on sentencing guidelines, and they're testing their ability to do the role, basically. The LAC will then create a list of the persons that it recommends and send them to the Lord Chief Justice. So once appointed, the training of magistrates is going to be fundamental to the effective carrying out of their duties, particularly when you bear in mind that they are not legally qualified. All magistrates have to satisfy regular appraisals based on a series of agreed competencies, and Her Majesty's Courts and Tribunals Service and the Judicial College provide core training geared towards meeting these competencies. And all magistrates receive their training before sitting and also continue to receive training throughout their service. A little diagram here showing you an outline of the training that they receive. And in the first year, they have initial introductory training, and before sitting in court, a new magistrate will undergo mandatory introductory training to learn more about their duties. And they will be assigned to a specially trained magistrate mentor. And there are 6 formal mentored sittings in the first 12 months where the new magistrate's progress and training needs are reviewed. And they have what's called initial core training. And all magistrates must attend an induction course to give them the required knowledge to sit in court. And in the first year, there'll be visits to penal institutions, court observations to supplement this. And consolidation training, at the end of the first year, consolidation training helps magistrates plan their ongoing development and prepare for their first appraisal. And about 12 to 18 months after appointment, the new magistrate is appraised. And a magistrate who's been specially trained will sit on the bench and observe whether the new magistrate successfully demonstrates the competencies required. And you can see here that the training is delivered by the Justice's Clerk, who's guided by the syllabus produced by the Judicial College, which is the body that trains judges. You can see here that magistrates usually retire at the age of 70, and the Lord Chief Justice can remove a lay magistrate from office if they have incapacity, meaning they're not able to do the job, or misbehaviour. Also, if they're persistently failing to meet standards of competence, so they're not meeting the training standards that we looked at in the previous slide, or if they're neglecting duties. And you can have a little research. I found an article about a magistrate here being removed from office after he fell asleep during a trial. If you've got situations like that, complaints about magistrates can be made to the same body that you would complain about paid judges, and that's the Judicial Conduct Investigation Office. In terms of diversity statistics here from 2019, in terms of gender, you can see that we've got a pretty representative bench of lay magistrates. Similar, I mean, women overtaking men for once here, but similar men and women represented. But the age of our magistrates is not very representative. You can see here that only 5% of our magistrates were under 40 in 2019, and 52% over the age of 60, average age being 57. And perhaps that's not surprising given that the role is voluntary, so most people who are going to be in a position to be able to volunteer are likely to be retired persons. You can see predominantly white sat as lay magistrates as well, with 88% compared to 12% over here, so not very representative. We will look at an evaluation of lay magistrates in a separate video tutorial when we'll also be looking at evaluation of juries.